sometimes the judge will say, you know what, you're right, I did make an error, and they will fix that.
So let's talk a little bit about how you set up a case to successfully um, appeal it, because you have limitations on what you can enter into, and most people don't understand the whole process. So I want to dig into that, because so that maybe the audience can kind of understand just the idea of an appeal and the idea of setting up the case while you're adjudicating things, so that you can appeal. Can you just talk in a general, and then maybe I'll have some more specific questions?
Sure. So the primary problem that I find when people come to me on an appeal is they will bring me the record and they'll say, most of my referrals for appeals come from the trial attorneys who don't want to handle the appeal or don't feel capable of handling the appeal, because trial level work and appellate work are just totally different animals. But a trial attorney will come to me with the record and say, these are the mistakes, the errors that I see, that I think should be corrected. And I'll look at the record and I'll absolutely agree with them. I think there were errors made and they are reversible errors. The problem is the requirements in all over the United States, but also in Virginia, is you have to preserve that error. And by preserve that error, I mean you have to timely and specifically give the judge the opportunity to fix an error before you're able to appeal it. So, for example, if the judge makes a wrong evidentiary ruling, but the trial attorney doesn't stand up and object, then that issue isn't preserved for appeal and the appellate court won't review it. Alternatively, if they stand up and object, but they make the wrong argument, that's also not appealable because you haven't given the judge the opportunity to correct themselves. So that is, I think, one of the overarching issues when I get an appeal from somebody fresh from a trial is, have you preserved your issues for appeal in the first place? Can I even help you?
So what if someone has not done a good job, preserving the issue, and it's something that was discovered, after the trial is completed, and that attorney didn't really address what was maybe even an egregious issue? And then how do you help that client to prosecute that? I don't know if prosecute's the right, but to file that appeal.
So a lot of times, unfortunately, that's fatal to the appeal. But there are certain situations where I can get involved and file post-trial motions. So essentially a motion that's filed after the trial is over, and preserve that issue for appeal. Not all the time. There are some issues and some errors that have to be addressed at the time that they're made. But there are other times where if you file this post-trial motion, give the judge an opportunity to correct what was done, then we'll be able to appeal. And it actually serves two purposes. Sometimes the judge, and I've had this happen, sometimes the judge will say, you know what, you're right, I did make an error, and they will fix that. And then we don't even have to go through an appeal. But that's a limited circumstance. And, it's good to consult an appellate attorney if you are a trial attorney to see what can be done if error wasn't properly preserved at that time.